From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Supreme Court issues a written code of conduct for itself, but will it quell critics of the justices? And President Trump proposes in a second term to launch a free online federal university. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnist Kim Strassel and editorial board member Mene Ukwe-Barua. On Monday, somewhat out of the blue, the Supreme Court issued an ethics code. A bit of the statement that precedes it, it says the undersigned justices, and that includes all 9 of them, are promulgating this code of conduct to set out succinctly and gather in one place the ethics rules and principles that guide the conduct of the members of this court. They say that these are not mostly new rules, and the court has long followed a set of principles, common law, ethics rules, or the equivalent. But the absence of a written code has led in recent years to the misunderstanding that the justices of this court, unlike all other jurists in this country, regard themselves as unrestricted by any ethics rules, and they are intending to dispel that misunderstanding. Kim, what do you make of this? On the merits, I guess, what's in this ethics code, and then also the strategic decision here, it seems, to issue this amid a campaign of political pressure against the Supreme Court.
Well, in terms of what's in it, I think that was a very good explanation at the top. Look, one of the misconceptions that has been out there promulgated by Democrats is that the Supreme Court somehow doesn't have any ethics code or ethics rules and it's free to do what it wants. That's never been the case. It adheres by and large to most of the rules that exist for lower court jurists. And so this is a restatement of a lot of those principles, as it were, and we can just run through a couple of them. You know, it says that justices should not allow family, social, political, financial, or other relationships to influence their official conduct. It lays out some principles of recusal, those cases where a judge might have a personal bias in a case, where the judge might have had prior representation in the case, where the judge or a spouse or certain family members might have a fiduciary interest in the case or be a party to the proceeding. It also lays out things that justices can do in terms of the public. It's very expansive when it comes to traditional things that judges do, like speaking and writing and teaching. But it does lay out some lines that they should not cross. For instance, speaking in front of political parties, speaking in favor of a commercial product, speaking to groups where they have a financial interest in a case that is before the court. So, I mean, these are all common sense, right? And the judges have long followed them. And that gets to why they issued them, which I do think is more of a problem. They've been under intense pressure and criticism from folks like Dick Durbin, who heads the Senate Judiciary Committee, Rod by Sheldon Whitehouse. Their interest, by the way, is not in bettering the conduct of the court. They know that there's not a problem there. Their only interest is in trying to impose some sort of outside standard by Congress that will force conservative justices to have to recuse or even go into retirement at the will of Congress so that they can try to juke the outcome of cases. And sure enough, these guys came out and said, oh, well, yay, first step done. The court has at least acknowledged it has a problem, but we have a problem because there's no enforcement mechanism here. They're not going to stop. Let's just be clear. These guys are never going to stop on the left until they can somehow rejigger the rules of the court in a way so that they feel they can win cases again. And I worry that all of this has done in issuing this new code is, again, suggests that there's a problem and just give further ammunition to those on the left that want to go further with some sort of congressionally imposed legislation on a co-equal branch of government.
Let's listen to Rhode Island Democratic Senator Sheldon Whitehouse reacting to the issuance of this ethics code in a video on social media.
The Supreme Court has at last acknowledged that it needs to have a code of ethics and has formally adopted one, which it kind of had all along. So the real test now is, how do you enforce it? Is there a place where you can file a complaint against a justice? Who sorts out the ridiculous complaints from the legitimate ones? For the legitimate ones, who does the fact-finding about what happened? Once you know what the facts are, who compares what was done to what is allowed under this new code of ethics? And do we get a public report at the end that explains? Really, really basic questions. They need to answer those, and until they do, that job is not done.
Monet, nice of Senator Whitehouse, I guess, to acknowledge that the Supreme Court has had an ethics code all along, even if it hasn't been in a publicly available written document like we now have that was released on Monday. But I think the worry here is that even if the substance of this ethics code is fine, the people who are attacking the Supreme Court are taking this as proof that the justices are sensitive to the political pressure that they have been bringing against the court. And to my mind, if Chief Justice John Roberts is thinking that this will deflect the kind of attacks that we've witnessed in recent months, it may only encourage more of them because the critics think that what they're doing is working.
Exactly. I think it's interesting to try to think about the origin of this code of conduct. As you said at the top of the show, it did seem to come somewhat out of the blue. I don't think it was widely known that the Supreme Court was working on something like this until it appeared Monday. But I think it's worth speculating about how it might have come into existence. It's very likely to me that Chief Justice John Roberts was the originator of it, in part because he's known as a real institutionalist, someone who thinks about the legacy of the court, its appearance of legitimacy, and tries to take decisions, sometimes even making legal rulings that are oriented towards shoring up the public perception of legitimacy. And so obviously he's been disturbed by the attacks that we've seen over the past few months against certain justices. And Chief Justice John Roberts also likes to try to build a bridge to the three liberals on the court and has shown himself able to do that. And so I could easily imagine him thinking we need to put together a list of principles that will be acceptable to all nine of us to show that we're united on this issue. And I'm sure that his thinking was that releasing something like this would help to quell the attacks, because anytime Sheldon Whitehouse or Dick Durbin or another one of these Democrats who has called the legitimacy of the court into question launches an attack at, say, Clarence Thomas for one of his activities, all of the justices would be able to point to this code of conduct and say, of course, they wouldn't say this publicly, but the implication would be you might be troubled by one of the justices' actions, but it clearly is inside the lines of these rules that we've all agreed to, and so we're not going to join you in calling for his recusal. But as you've been pointing out, the actual consequence of releasing the code of conduct might be the opposite of quelling the criticisms, because its release does seem to suggest that the court agreed that there was a problem that needed to be addressed. I don't think that that was Chief Justice Roberts or anyone else's intention on the court, but it's very clear that that's what the spin is and will continue to be from the progressives in Congress who want to actively regulate the court. Again, because Samuel Alito has suggested that there is no power of Congress to regulate the court, and that principle is affirmed in the code of conduct, it seems unlikely that any congressional action to try to actually create enforcement mechanisms would really stand judicial scrutiny. But I think it will be damaging to America's legal culture that this is probably going to become an item of belief for Democrats moving forward. They're going to continue to say that we need regulation, and they're going to continue to say that every ruling that comes out of the Supreme Court is illegitimate until we have it.
Kim, on the details of this ethics code, you mentioned the recusal rules, and I'll focus in on that one. I do think that this might be helpful in letting people who are outside of the Supreme Court building in on some of the mysteries. There has been, typically the Supreme Court works behind something of a veil. They come out and they issue their judgments and they hear their cases and their oral arguments, but it's not always clear what is happening behind the scenes there, why a certain justice might have recused from a case, to take the example at hand. And so I do think there is some helpful clarity in some of these rules that they have now written down now. So, for example, it says that recusal may be appropriate if the justice or the justice's spouse, or if a person related to either within the third degree of relationship is a party or a lawyer or is involved in the case in some sort of way. It can go down further, and it says that it explains what the third degree of relationship is: parent, child, grandparent. It goes on: sister, brother, aunt, uncle, niece, and so forth. It says that neither the filing of a brief amicus curiae nor the participation of counsel for amicus curiae requires a justice's disqualification. I think that is important to say for the record. These are friend of the court briefs that come up in cases, and the Supreme Court has been very liberal in allowing those to be filed by anyone who takes an interest in the case. And that's something that Sheldon Whitehouse has been upset about, because he's drawing these lines on his chart between this person knows this justice and also that person donated to this think tank, which filed an amicus brief in this case. I think it's useful to have that on the record. The justice is saying that these are briefs that come in from people who take interest in cases, and nothing about the participation of those people or the filing of those briefs is going to knock us off of these cases. But the other thing that I think is important to examine is what Sheldon Whitehouse means when he talks about enforcement. He has a bill that he has put forth. Under his rules, any party with a case before the court could make a motion that one of the justices be recused. And then the other justices, as I understand it, would have to rule on that motion and decide whether to kick their colleague off the case. Even more odd, it has this process where any member of the public could file complaints against the Supreme Court, against the Supreme Court justice for behavior unbecoming, and those would be investigated by a panel of lower court judges. And I think there's some real questions here, first about the constitutionality of that kind of thing, having lower courts investigate Supreme Court justices, having Congress demand that of a co-equal branch of government, but also the practicality of them. If you give parties the opportunity to ask the justices to knock each other off of cases through these kind of recusal motions, it seems to me that big cases would end up as battles over which justices even get to hear them in the first place.
The specificity of this bill, I think, is useful, although mostly just for explaining to outsiders the rules that the justices have followed for a very long time. The definitions, there's a whole long page of definitions, as you say, about what counts as a family member, etc., different legal terms in terms of what does fiduciary interest mean, etc. This is all, I think, clarifying for those who are looking at the court. It's also useful, the specificity of noting bluntly the nonsense of the amici point and these amicus briefs that come in. The only question the justices need to look at is whether or not they have financial interest in the case or some sort of bias in the case itself. The question of who comments on that case and offers an opinion to the court is completely separate from that. And it's good to see the court make that clarification. But here's what I like about the specificity more than anything, which is that the court also, underlying all of this, makes very clear this fundamental principle of the Supreme Court, and this goes to your point about recusal, that this court is different than any other court in the country. There are only 9 justices, and unlike lower courts, if one of them recuses, there is no fill-in, there's no replacement. And that has the potential to leave the court with tie votes or not have the amount of statement that it might otherwise, but it came out, if it doesn't have a full court coming out and making a ruling, it can undermine the strength of that ruling. So it's extremely important that the justices sit if they can. And there's a couple of points in this doctrine where they note that all of these standards are good and fine, but for instance, there's a catch-all phrase in here that says, but the rule of necessity may override the rule of disqualification, meaning if a justice really feels it's important that they be there, that is a judgment call they have to make. It also begins by saying a justice is presumed impartial and has an obligation to sit unless disqualified, meaning that the bar needs to be really high for disqualification. This is something that Sheldon Whitehouse and the left hate because that's their whole game plan. Again, this legislation that they have come up with is designed to give outsiders and progressive groups the ability to complain and raise challenges to who should be allowed to sit and come up with this convoluted process, all designed to fix the outcome of votes that progressives don't like at the moment.